Everybody, and welcome to our webinar on clinical data and privacy. Tonight we're going to highlight the impact of recent changes to the privacy legislation, and we're going to discuss some practical challenges in ensuring health information remains private and secure in the digital age. And tonight we have a panel of experts from a range of disciplines in the healthcare space, and we're going to look at what clinicians really need to know about some of the changes and provide practical advice on how to minimise their risk when dealing with and sharing personal and clinical information. Before we begin as well, as the message said, the chat has been muted, so you'll be able to hear the speakers, but we can't hear you. We do have an inbuilt function that will allow you to send through some questions, or you can use the question function and we'll address those at the end. Also, feel free to get in contact with any of the presenters at the end of the presentation. More than happy to answer further questions you may have. And we'll also try and make a copy of the slides available for you. So our first speaker is Emma Harmon, and she's an associate with Barry Nilsson Lawyers. She specialises in health law with experience representing both hospitals and practitioners in medical negligence proceedings and disciplinary cases. She also advises on numerous related regulatory issues. After Emma, we will have Dr. Katja Beitat, and Dr. Beitat is the CEO of Healthcare Innovate. They're a company that specialises in secure communication for health providers. Dr. Beitat also previously worked with the New South Wales Healthcare Complaints Commission, and certainly brings together a wealth of experience and knowledge to help practitioners address and understand on the practical level the risk and challenges when using different types of technology for clinical information sharing. So without further ado, I'll hand over to Emma to talk about some of the changes with the new notifiable data breach scheme.
Excellent, thank you, Eric, and welcome again to the webinar. As Eric mentioned, my name is Emma Harmon, and I'm going to provide an overview of the notifiable data breaches scheme with a focus on the health sector, and finish by looking at some cases where practitioners and healthcare organisations have been found to have breached patient privacy. So the idea of it is to give you an idea and overview of the triggers and thresholds that you need to be aware of under the new scheme and how to respond if there has been a breach. And then after that, I'll hand over to Dr. Katja Beitat to talk about the impact of the privacy law changes for practitioners and ways that they can look to store their clinical data more securely. So I'm going to start by looking at the key information about the notifiable data breaches scheme. It's worth noting that before the changes, entities could voluntarily notify the Information Commissioner of data breaches. So the key change to remember about the scheme is that now, in some circumstances, notifications are mandatory. The scheme is set up by amendment to the existing Commonwealth Privacy Act and contained in Part 3C of that Act. So who does it apply to? Well, it applies to all organisations that already have obligations under the Commonwealth Privacy Act, otherwise referred to commonly as APP entities. So this relevant to us includes private sector, health service providers, as well as Commonwealth government agencies. It's interesting to note at this point that private sector businesses in other industries need a turnover of $3 million or more before they're caught by the Act. However, health providers are required to comply irrespective of their turnover, reflecting the highly sensitive nature of health information. So the scheme does not generally apply to state and territory public sector providers, for example, public hospitals, which are regulated by state and territory privacy laws. That said, the scheme does apply to tax file number recipients. So this means that public entities that hold tax file number information could also be subject to this scheme if that tax file number information is involved in the data breach. I want to look quickly at what a health service is under the Act. It's defined very broadly as any activity that involves assessing, maintaining, or improving a person's health, or diagnosing or treating illness. So this means that organisations that would be caught as private health service providers would include, as you'd expect, traditional health service providers like hospitals, private hospitals, medical practitioners and pharmacists, as well as complementary therapists like naturopaths or chiropractors, but also it could extend to gyms, weight loss clinics, childcare centres and private schools. So the breadth is quite broad. And why has it come about? Well, personal information, particularly in the health sector, is becoming increasingly mobile. There's near instant access to information is demanded by patients, and there's huge benefits through all of this for treatment. So the scheme looks to balance these huge benefits with the individual's right to privacy, as well as what the community expects in terms of transparency if a serious breach does occur. In this respect, there was a survey, the Australian Privacy Survey last year, which found that 94% of Australians believe that they should and have a right to be told if a business does lose their private information. The changes also bring Australia into line with other developed countries. Most US states, for instance, already have mandatory notification requirements, and the EU has recently introduced the Comprehensive General Data Protection Regulation, which applies from this Friday, 25 May. And when is it in force? Well, the scheme commenced, it's already commenced, so it commenced on 22nd of February this year, which is some 11 years after being first introduced to Parliament back in 2007. The first quarterly report on the scheme was released in April, so it really only looks at the first 6 weeks of the scheme being in force. And as expected, the healthcare sector was the most highly represented, with nearly a quarter, 24% of notifications. So what does it do? The scheme places a mandatory obligation to report not every data breach, just eligible data breaches. And an eligible data breach occurs when there's been unauthorised access to or disclosure of personal information, or a loss of personal information, i.e. the data breach. And it occurs where that breach is likely to result in serious harm to any of the individuals to whom the information relates. Now, in that definition, there's a lot of key terms, so I want to go through a couple of them. Personal information is one of them. That just refers to information that could identify an individual. So things like names, obviously, signatures, addresses, telephone numbers, date of births would have been included there. And unauthorised access, well, that can be as simple as losing a mobile phone which contains personal health information, or, for example, if medical results are emailed to the wrong address, or it can be as serious as where a database is hacked. And in terms of what serious harm means, well, that's not defined under the legislation, but the explanatory memorandum does give some guidance. It states that serious harm involves serious physical, psychological, emotional, economic and financial harm, as well as serious harm to reputation and other forms of serious harm that a reasonable person in the entity's position would identify as a possible outcome of a data breach. So it needs to be more than a person just becoming upset about a breach of their personal information. There's a lot of examples that you could think of here, such as sensitive or embarrassing treatment records being disclosed, or disclosure of addresses and contact numbers where there might be a custody dispute or AVOs in place. The Privacy Act in Section 26WG lists a number of relevant matters to take into account in considering whether serious harm is likely to occur as a result of the breach. The key things to take into account are the kind of information that was accessed and how sensitive that information is, who could access the information, and the type of harm that could result. So what do you need to do if you suspect an eligible data breach has occurred? Well, the first step should be to identify the breach, and this means to understand exactly what information has been affected, and then take steps to contain the breach. This might mean taking steps to limit any further access to the information or further compromise of additional information. So you might, for instance, need to close down a website. Then, if an entity suspects that an eligible data breach has occurred, it must investigate within 30 days. What that investigation needs to look at is set out in the Act. However, the crux is considering whether or not there has been serious harm or whether serious harm is likely to result. And then if an entity doesn't just suspect but believes that an eligible data breach has occurred, it needs to notify the Information Commissioner and all affected individuals as soon as is practicable. Now, you can notify the Information Commissioner via an online form on its website, which is quite comprehensive. And if an entity can't, for whatever reason, contact all of the individuals that might have been affected directly, they can take other steps like putting a notification on their website or advertising on social media to bring attention to the breach. Entities should also take remedial action if that's possible to prevent serious harm occurring. So this means that if the remedial action is effective and then serious harm doesn't actually eventuate, the breach isn't an eligible data breach and you don't need to notify. So an example of where remedial action might be successfully taken is where, for instance, a practitioner leaves their work mobile phone on a bus. They get to work and immediately report it to IT, who remotely deletes that information on their phone. And then because their phone, for example, is password protected, IT is fairly confident that there was no unauthorised access in the short period of time between losing the phone and deleting the personal information. So what are the consequences? Can complain to the Office of the Australian Information Commissioner, which may prompt an investigation. OAC can also investigate data breaches even if there hasn't been a complaint made to them. After investigating, the Commissioner will need to look at whether there has been an interference with an individual's privacy. And the Commissioner has fairly broad enforcement powers, and they might also decide to require an entity or person that has breached the Act to compensate individuals for any loss or damage suffered, or alternatively take steps to ensure the breach doesn't happen again. And they can also seek an injunction from the court to prevent ongoing breaches. And I'm sure, as you might have heard, there are significant financial penalties if there are serious and repeated failures to comply with the notification requirements. In this case, the Commissioner can apply for civil penalties of up to $2.1 million in the case of a corporate entity and $420,000 in the case of individuals.